Most people are trying to get items removed from their credit report through one angle, which is disputing through the credit bureaus. In this video, I'm going to show you a different angle. We're going to be attacking the furnishers, right? Most people don't think about doing it from this angle, so this will continue my series I've been doing as far as helping y'all being able to delete any negative item in 2025 and beyond. Just for validation's sake, I've been doing this since 2021. You can go to my channel, look at the different videos, different playlists, and go from there. I'm not going to sit here all day and convince you why you should listen to me. All right, let's get straight to it. So, 15 USC 1681 S-2, responsibilities of furnishers of information to consumer reporting agencies. I'm going to talk about a specific court case that went wrong and why it went wrong so y'all can have further knowledge on what y'all actually need to do. So watch the entire video. I'm going to have a surprise for you at the end as well. So when we look at it, 1681 S-2B, if you don't know, 15 USC 1681 is the FCRA, the Fair Credit Reporting Act. I'm going to assume you've watched some of my videos. You know what the FCRA is. You know what the FDCPA is. If you don't, go on my channel, go look at the 4-hour masterclass where I broke down the language of both. But anyways, so duties of furnishers of information upon notice of dispute. So the furnisher of the information is the creditor, the furnisher is the debt collector. Those are the furnishers, essentially. They give the information to the credit bureaus to report. Most people, what they do is they'll send their dispute to the credit bureaus, which is good practice and what you should do, but they don't think about holding the furnishers accountable as well, right? So keep that in mind. So you see, they say after receiving notice pursuant to 1681 IA2. If y'all go look at past videos, I've told y'all 15 USC 1681 I, the I section, the investigation section, is a very important section for the credit bureaus. We're looking at 1681 S-2. This is very important under the FCRA for the furnishers. So I'm hoping that this is making sense. 1681 E is also important too, the maximum possible accuracy. So just keep that in mind. So the duties on the furnishers. What are the furnishers even supposed to do? They're supposed to conduct an investigation with respect to the disputed information. So when you, as a consumer, send a dispute, it doesn't matter. It could be a charge off, it could be a collection, it could be whatever, right? If it's a collection, maybe you're disputing the amount, maybe you're disputing, the validity, whatever you're disputing, right? The validation is going to be with the debt collector, but just to give y'all an example, maybe it's a charge off, you're disputing the amount, the payment history, or something, right? You're disputing something. So they have to conduct an investigation. That's fair to you, right? So then they're supposed to review all relevant information provided by the Consumer Reporting Agency, aka Experian, TransUnion, Equifax, pursuant to 1681 IA2. Go look at 1681I and reference everything that they're talking about here, right? Because it's going to be very important for y'all to understand from multiple angles what's going on. They're supposed to report the results of an investigation to the Consumer Reporting Agency. So basically, just as a summary, what happens? You dispute, okay, I need this item deleted. It's actually inaccurate. You point out the inaccuracies. And then what happens? Let's say Experian, they send you a letter or they let you know, like, oh, verified, right? And that whole process, what's actually supposed to happen is Experian, TransUnion, Equifax, they receive the dispute from you. They're supposed to notify the furnisher, right? So that notifying the furnisher is going to be very important, right? When we talk about having a legal standing claim, you've got to make sure that you have reasonable, like, proof that Experian, TransUnion, Equifax actually reached out to the furnisher. And then you're going to see in the case that we're going to talk about, that's a very pivotal part of that, right? So if the investigation finds that the information is incomplete or inaccurate, report those results, etc. It's very just like when you're requesting a reinvestigation from the credit bureaus. So keep that in mind. They're supposed to modify it, delete it, block it, right? So cool. This is the important part. To actually have a claim under 15 USC 1681 S-2B, this is what has to happen, right? So a consumer, meaning you have to alert the credit reporting agency, which is who? Experian, TransUnion, Equifax, of your dispute regarding the allegedly inaccurate information that's being reported. So you send out your dispute letter. Of course, you want to do that certified mail so you have proof that you did it, right? So that's important. Cool. Boom. We did that. So you have to also allege that the CRA alerted the furnisher of the information of the dispute, that's gonna basically trigger the furnisher's duty to investigate, right? Because if you don't include this part, which is very important, you're gonna have a court case that gets thrown out. And then you have to basically allege facts that shows the furnisher actually failed to do a reasonable investigation of the disputed information. So whatever your situation is, whatever you're actually disputing, the accuracy and completeness, whatever, you got to have proof that they didn't do a reasonable investigation. So anything less than that, if you do decide to take it to litigation, or if you're working with attorneys, like what we do, we work with attorneys at this point, just because my main focus is the funding. If you don't know, our mission is to help fund $1 billion to small business owners. Part of that, obviously, the foundation is personal credit. That's why I do all this consumer law shit and help y'all, with this at least. So, yeah, keep that in mind. So, if you don't have all three of those elements, they're gonna be able to basically dismiss your claim. There's something called Rule 12B, number six. They can hit you with that, right? That you don't have a claim where relief can be granted. It's just like legal jargon stuff. If anyone's an attorney watching this, they know what it is. Or if you're a consumer that's at least hip a little bit, you know what that means. So let's give y'all an example of ideal winning situations. So an example is a court finds that the debt collector, which would be the furnisher of the information, they failed to adequately investigate a disputed debt, and they continue reporting inaccurate information after receiving notice of the dispute. So whatever's inaccurate on that. When the debt collectors get it, they don't get everything fully accurate, right? So over that whole transfer period, which is already a violation of that process, maybe they got information that wasn't accurate. So you sent your dispute, you have all three of those elements that I'm talking about. You sent the dispute, obviously, the credit bureaus received it, and then it triggered the investigation because they notified them, right? So, that helps you. So one practical thing is requesting the I've told y'all this method of verification. So under 1681I, number 7 under the FCRA, that's basically going to help you request a method of verification. So when they say all this verified stuff, if you request a method of verification, they're supposed to let you know what they did to find that. So they gonna say like, oh, we notified the furnisher and all that, right? So that's boom, that's your trigger. So then you can hit it from a different angle here with the furnisher, right? So once you actually have that alleged facts that they didn't do a reasonable investigation, and you'll know that based off of your situation. I don't know what your situation is. I don't know if it's inaccurate payment history. I don't know if it's inaccurate balance, that type of thing. So I don't know if it's not tied to you. So keep that in mind. So a different example, maybe a court finds that the creditor failed to properly investigate a dispute regarding the accuracy of payment history, right? Like I said, reported on a credit report. So sometimes payment history is off. Most credit reports have something that's off. So you just got to look at your reports and analyze it. I always tell people look at your actual credit reports. What's your actual credit reports? Your actual credit reports from annualcreditreport.com. The monitoring services are cool, but in my experience, from what I've seen, you give them reason to be like, okay, that's some third party thing that's not even aligned with the government website. So you don't want to put yourself in a position to where they have some type of leverage. You want to give yourself the maximum leverage. The maximum leverage will be going to annualcreditreport.com, right? I've been doing this since 2021, so listen to what I'm saying, especially if you're new to this shit. All right, so an example as well, a court finds that a furnisher failed to respond to a dispute within the required time frame, right? So look at the time frame as well. If you didn't get no response based off of your letter, right? This is why you want to do things certified mail. So based off of that 30, 40-day time frame, you want to make sure that you're monitoring the time frame as well, because under the FCRA, if they're not doing an investigation in a timely manner, you can trigger that. One thing I'll say too, though, if you do send a dispute, I wouldn't like, let's say you send a dispute, it's within the 30 days, let's say on day 15 or something, you send something again. You can actually reset that time period and buy them more time. So I would be careful doing stuff like that. Like when you send stuff out, let the full investigation go first, and keep track when you mail stuff certified mail. So yeah. So consumers cannot maintain a claim under 1681 S-2B based on this is where the court case went wrong. So based on stuff that's filed just directly with the creditor, directly with the furnisher, because it doesn't trigger them to have to be liable under the FCRA unless it's done through where, like I said right here, you allege that the CRA did alert the furnisher. So this is why you always want to request what was the method of verification so that the bureaus can give you that information. So whether the bureaus are saying that, oh, we contacted these people and that's where we got the information, or if they're lying or telling the truth, we just want to have that right there as proof that they claim that they did, right? So you can't just do it directly with the credit card company. So the case I was telling y'all about, it was Daniels versus Capital One. So you can go ahead and Google it. So Daniels versus Capital One, what happened was he sued Capital One and he alleged violations of the FCRA. But basically, he alleged that Capital One failed to provide information as to why it was holding him responsible for charges on his credit card account, which is cool. Capital One restricted his access, blah, 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 without investigating the fraudulent charges. But the thing was, he did it through Capital One. So they concluded that he failed to allege that he alerted the credit reporting agencies of the disputed charge of incorrect information that was being reported. So remember, 15 USC 1681, this is the Fair Credit Reporting Act. Fair Credit Reporting Act issues deals with the CRAs, right? So Experian, TransUnion, Equifax are always going to be relevant when it comes to statutes under 1681, specifically 1681 S-2B. So keep that in mind. So just again, an example of an ideal winning everyday situation. So a court finds that a debt collector failed to adequately investigate a disputed debt and continue reporting inaccurate information after receiving notice of the dispute. Remember, these things have to be in order, right? So maybe you also sent a debt validation letter and it can validate the debt as well. Because remember, when during the turnover process, these people at LVNV funding, all these collection agencies, they don't always get stuff fully accurate. And you always want to request the entire purchase agreement, right? And I understand that this stuff could be complicated and complex. So that's why I'm going to leave a link in the description so you can grab a free guide I made for you to be able to legally remove collections using these tactics. So with that being said, hopefully this was helpful. Share with someone, or if you want to help someone, and make sure you take action on it yourself. With that being said, y'all have a blessed one.